Shimada.
Hello, Shimada. We lost you.
Hello. Yeah. Just a moment. I want.
You have a bad signal, I think, Professor, because unclearly in your voice cannot to hear clearly.
Really. I don't know what's happened because my connection is very good. That 300 megabytes per minute.
Maybe in Japan is so far. Japan is so far.
So it must be very good, but I don't know what happened.
Now I can hear your voice clearly.
Yes.
Yeah. Okay. So may I start my presentation?
Yes, Professor. I will open this presentation. And then, good morning, ladies and gentlemen. Welcome to our international conference in the webinar. Ladies and gentlemen, may I have your attention, please? Our international conference is about the law and Islamic law. To begin, please have a nice seat.
Oh.
Thank you very much for preparing yourself to join our international conference. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Respectable the Professor Shimada from Nagoya University and Mr. Khanif, PhD from University of Jember, the Honorable all presenter and participant this international conference who has to join in this room, although in this virtual Zoom because of this pandemic, but we hope this pandemic will be lost and we always healthy. Amin, amin, ya rabbal alamin. Ladies and gentlemen, I am Ima Frafika Sari, the moderator of today's international conference. I'm glad to see you here and welcome all of you to this conference. Today's conference is about the comparative of law in Indonesia and Japan and the influence of Islamic law toward the Indonesia legal system. Ladies and gentlemen, our speaker today is Professor Shimada and Mr. Khanif, PhD. Let's meet to introduce Professor Shimada Yuzuru. He is from the Nagoya University and have many experience in teaching and learning. Actually, Professor Shimada now is a lecturer in the Nagoya University in Graduate School of International Development. And then about the research experience, Professor Shimada have experience in Indonesia in 1997 and 1998 in Gajah Mada University. He have a scholarship of the Japan Foundations, the Ministry of Foreign Affairs Japan, exchange student, Faculty of Social and Political Science. And about the research grants, here professor have many research that related with their interest research. And one of the research is about the Indonesia constitutions, is about in the year of 2019, and the persons is about research on the post-authoritarian constitution model, the constitution and constitutionalism in the Reformation era. I think in Indonesia, so here many research is about the Indonesia era for their research. And then about the background of education, professor have the background in Master of Arts in Nagoya University and then PhD in International Development Studies in Nagoya University of Japan. Welcome to our international conference, Professor. For ladies and gentlemen, before the presentation begins, let me inform you have a presentation will be going on. First, Professor Shimada will be invited to present the material. And then Mr. Khanif, PhD, will be invited to present the material. After that, there will be a question and answer session and followed by conclusions. Now, allow me to welcome the first speaker, Professor Shimada, to deliver his presentation. Professor Shimada, the room is yours.
Thank you very much, Mrs. Moderator. So, and first of all, I have to apologize because due to my sudden schedule change, I had to cancel my presentation first scheduled in yesterday. So because I have to go to the airport yesterday to to meet our former students from Afghanistan. So they are they evacuated from Afghanistan. So and I have to accept them in the airport. That's why that I couldn't have the my presentation scheduled yesterday. And so and I asked to the organizing committee and Al Khanif to move my presentation to today. And furthermore, that I had to say, I was late for this session because due to my lecture for my students. So, and I deeply apologize that your inconvenience. And next, I'd like to ask you that which screen are you seeing, that the presenter's view or the full screen view?
Your first page of your presentation.
Okay, that's good. Okay, so that I'll continue. So that organizing committee asked me to discuss about the comparative law in Indonesia and Japan. So based on this topic, I choose my presentation topic is Indonesian law and Japanese law is similar. So socio-legal approach in comparative law. First, let's see the two articles from the Indonesian Civil Code and the Japanese Civil Code. The first is Article 1365. It's the most famous article in Indonesian Civil Code. So, and I think that almost all cases that the civil litigation decided based on this article. It's the Civil Code of Indonesia, Article 1365 says that every unlawful action that brings damage to other person obliges the person by whose fault causing such a loss to compensate such a loss. So this is so-called the tort liability. And in Japanese Civil Code in 709, which has a very similar rule that it says a person who has intentionally or negligently infringed any right of others or legally protected interest of others shall be liable to compensate any damages resulting in consequence. I think of course that the text or the phrases of these two articles are different, but this difference is only due to the translation. I said that the contents of two articles is the same, but both articles provided that the total liability, that anyone who damaged the other's interest illegally, that who have the liability to compensate damage. So that means that the Indonesian Civil Code and Japanese Civil Code has a very similar article in it. So from this point that I give the question, whether that the Indonesian Civil Code and Japanese Civil Code or Indonesian law and Japanese law is similar or not. If we read these two articles, we can conclude that Indonesia and Japan has a strong similarity in their laws. But is it a good conclusion or not? So this is my starting point today. Okay, let's see the next slide. This is the contents of the civil codes in Japan and Indonesia. So Indonesian Civil Code from the 3 books. Sorry, because I think my Indonesian is more fluent than my English, but that's why that sometimes I omit the translation. I just bring from the Indonesian original text. According in the Indonesian Civil Code, the first book about the orang, person, and the second book is about the barang, goods, and third book is about the perikatan. How to say it? Perikatan is a contract. And fourth one is a pembuktian dan kedaluarsa, the evidence and the time effect. So this is it's composed, the Indonesian Civil Code, except the family law, is composed from the 4 books. And if we see the civil code in Japan, the structure, the content of the Japanese code is very different. Japanese code, civil code is divided to the 5 chapters, and chapter 1 about the general provisions, and second chapter about the real rights, and third one is the claims, and fourth one is family, and fifth one is inheritance. So how do you think, if you compare the structural contents of the two codes, maybe you impressed that the contents is very different. And actually, the Indonesian Civil Code is that the follow to the French Civil Code. So that the French Civil Code or Napoleonic Civil Code is use this structure: person, goods, contracts, and the evidence and the time effect. But the Japanese Civil Code, it's follow to the German Civil Code. So German Civil Code starts from the general provisions, which provide about the general rule, which can be applied to all the civil code issue. And then that the move to the divides the civil code issue to the 2 things. One is the real rights, rights on the goods or property. And the third, and the claims based on the contract. That the claim is not the real rights, it's rights caused from the contract. So, and family and inheritance, because in Indonesia, family issue and the inheritance issue is governed by the other religious rule. That's why the Indonesian Civil Code doesn't have the 2 chapters in Japanese Civil Code, family and inheritance. So maybe that if we compare the structure of the Indonesia and Japan, that the Indonesian Civil Code based on the French Civil Code, and then Japanese Civil Code based on the German Civil Code. So from this view, that we can say that Indonesia and Japan is different, while the Indonesia and Japan has a very similar, almost same article about the total liability. Okay, but we should consider whether this conclusion is right or not. Okay. Let's move to the next point. So maybe that I think that the comparison between Indonesia and Japan is not enough only if we compare the phrases of each articles, and also that the compare between the structure of each codes. Maybe we should see the historical development. If we see the history of the Indonesian Civil Code, that we can, how to say, we should see the history of Europe. In 1789, there is a French Revolution, so-called the Great Revolution. And after the French Revolution, that the French Revolutionary Army occupies the Netherlands, and they established the Republic of Batavia. So the Republic of Batavia is a de facto, how to say, puppet state of the France. That's why that we can say that the Netherlands became a part of France after the French Revolution. And in 1800, the Emperor Napoleon ordered to make the codification of the French law. And finally, in 1800, the Napoleonic Code was established. And Napoleonic Code is the most systematic codified rules at that time, including the civil code, criminal code, and civil procedure, and the penal procedure, and administration, and the commercial activities. So it's the most developed and systematic code. So, and in 1855, the Republic of Batavia changed to the, in 1815, that the Netherlands, recover its independence. However, that during the 20 years under the French occupation, that as a part of the French, as a part of the France, that the Dutch society couldn't be free from the impact from the legal revolution in France. And during this time, the Dutch society accepted the Napoleonic Code. And even after the recovery of the independence in 1815, the Netherlands finally decided to accept the Napoleonic Code as its civil code. So this means that the Netherlands accepted the French code even after the independence. And 1847, the Dutch colonial government in Indonesia enacted the Burgerlijk Wetboek, so-called the BW, as the civil code which can be applied to the Dutch East Indies. And this BW accepted as a valid civil code in the Republic of Indonesia, independent Indonesia. And now that the Indonesian people considers that the BW as a civil code of Indonesia. So this is the root of the civil code of Indonesia, which the accepted this BW it have the root in the French code, even though it's imported to Indonesia via Netherlands. And in contrast, in Japan, so if we see the history of the civil code in Japan, we should start from the Meiji Restoration. It's the beginning point of the modernization in Japan. It started in 1867, Meiji Restoration. And in 1867, Japan started the modernization and start building the modern, strong, centralized states. And one of the important factor for the modern, strong state is a modern legal system. So, and in order to have the modern legal system, Japanese government tried to import the Western legal system. And in order to speed up the legal reform, modern legal reform in Japan, Japanese government invited one French professor. So his name is Boissonade. Professor Boissonade arrived at Japan in 1873. And he supported the Japanese government to draft the civil code. Of course, Professor Boissonade is a French professor. That's why that his draft also based on the French code. And based on the draft made by the Professor Boissonade, Japanese parliament how to say, adopted the first civil code in 1890. This is a so-called first civil code. And actually, that the first civil code is the structure or the contents of the first civil code is based on the French code. And it's very similar to the Indonesian Bulgar alphabet book, because that the both are based on the Napoleonic code. But before this first civil code was enacted, some Japanese politicians opposed to the first civil code, because the first civil code based on the French civil code is too individualistic or too individualism oriented. That they claimed that this civil code doesn't match with the Japanese society and tradition. So, and as a result, the Japanese parliament decided to postpone the enactment of the first civil code, and the government ordered to the Japanese legal scholars to make the other draft. And in 1896, the Japanese legal scholars prepared the second civil code. It's and adopted by the parliament in this year. And now that the Japanese civil code, current Japanese civil code, based on this second civil code, even there it experienced many change many times. And actually, that the second civil code is based on the German civil code, because from Meiji Restoration to the 96, there is a drastic change in the European politics. In Europe, France became the weaker state, and Germany emerges as a new strong state. That's why that the Japanese government decided to accept the German civil code as the Japanese civil code. That's why that the Japanese civil code has a structure which is similar to the German civil code, different from the Indonesian civil code, which based on the French civil code. But actually, that the second civil code was not free from the influence of the first civil code. That's why that even though that the second civil code has a structure based on the German civil code, the contents of each article is very close to the French civil code. So this is the so-called that the Japanese civil code is a hybrid of the French civil code and the German civil codes. Anyway, from the continental law countries. So this caused the difference between the Japanese civil code and the Indonesian civil codes. Okay, now that we can say that the Japanese civil code and Indonesian civil code has similarity and difference, but actually these differences is not so big as appearance. Because if we see the detail and history, that both civil code come from the French civil code. Okay, but if we see the function of the, I wonder. Okay, if my voice is not clear enough, please remind me at any time.
Very clear.
Okay, so and if now let me see the function of the civil code, especially the tort liability provision article. So in real society, and okay, I will take the case in the car accident in Indonesia. Jika Anda menabrak mobil Anda kepada mobil lain, apa yang terjadi? Okay, so in Japan and actually that in Indonesia maybe follow the same process formally, if there is an accident, first that the two parties should have the negotiation about the damage, and they achieve the negotiation. Maybe that the damaging party will pay the compensation to the damaged party. But if not, maybe that either party calls the police, and the police makes a report about the crash accident, and based on this police record, two parties have the negotiation again. And if the two parties reach agreement, so maybe a party will pay the compensation. And if the negotiation couldn't be achieved, maybe that this case will be brought to the court, and the court first propose the compromise before the judgment. So, and lets the two parties to mediate or to reconcile before the final judgment. If two parties agrees the proposal of the compromise from the court, the party will pay the compensation. And if the two parties reject the proposal of the compromise from the court makes the judgment and decides who have to pay compensation or not. So, and the compensation. And after the judgment, a party can brought to the appeal court or the Supreme Court by this way. Well, this is the process. And in Japan, that the most cases is settled in this process, second negotiation process, after the police investigation. So that the most and the only few cases are brought to the court. So that the most cases that reached to the agreement in the second negotiation process. And in this process, in Japan, especially, the insurance company plays a very important role. Insurance company intervene to the cases, and they let the parties to have the agreement and pay compensation to settle the case. That's why that the court have the very few cases about the car accident, as far as not involve the people's life. How about Indonesia? This is my image about the Indonesian case, because I'm not the expert of the civil code in Indonesia. I'm an expert about the constitution. That's why that if I have the mistake, please indicate later. But in Indonesia also do the same process. But in my image, and as far as according to my knowledge, that the people or the party who involved in the accident rarely call the police. Usually, the people try to settle the accident by the negotiation between them without calling the police. So that the most cases is settled in the first negotiation process and done by the compensation. But of course, the amount of the compensation, it depends on the relationship between the two parties, and also that the economic capability of the each parties. So compensation is done without the police involvement. But interestingly, that some cases are brought to the court, and those once the cases are brought to the court, it's very difficult to settle the within the judicial system. Usually, that the court propose the compromise, but both parties reject, and the court make the judgment, but either party appeal this case to the court, that the high court, and then that the court again compromise, but either party reject, and high court give the second judgment. But these cases very often brought to the Supreme Court, and even after the Supreme Court judgment, that either party try the peninjauan kembali. I forget the in English, what is the peninjauan kembali. So that, and sometimes that either party that brought the other cases, even though the same object. So that there is an endless loop in Indonesia. So that once the cases in Indonesia, once cases brought to the court, that there is somehow the endless loop, and it's very difficult to solve the cases dispute within the judicial process. This is a characteristic of Indonesia. Okay, and what makes a difference between Japan and Indonesia in the actual dispute resolution system? Okay, and in order to consider this point, I'd like to refer to the Friedman's model. It's very famous that Professor Lawrence Friedman proposed this structure. So according to the Professor Friedman, that the validity of law is a result of the interaction among the substance of law, culture, and the implementing structure. According to the Professor Friedman, the substantive component of law means the contents of the legal regulations, substance. In this case, that substance is article, I forget that 1365 in Indonesia and article 709 in Japan. This is a substance. And actually that the substance of the law in Indonesia and Japan is similar or almost same. And then the substantive component includes any form of the regulations as far as they are actually used. So this is substantive, the context, text of the legal rules. But the structure includes the legal institution, the form they take, and the legal process. Therefore, the courts, government form, and the separation of power are kind of the constitution. Legal procedure are structural components of the working law. In case of the car accident, maybe that the court or role of the court or the role of police is a structural factor. And lastly, the cultural component means the values and attitude which bind the system together and which determine the place of the legal system in the culture of the society as a whole. Culture includes the culture of the legal professional and ordinary people. And especially that in case of the car accident, I referred that the culture is that whether called the police or not upon the accident, or whether people will use the judicial system or not. This is a cultural component. Maybe that the Japanese people normally avoid to use the judicial system. This is based on their legal culture. And also that the Indonesian people avoid call the police. It's based on their legal culture, cultural factor. Those, the substantial factor affected by the structural factor and the cultural factor and make the real working law. Okay, that now based on this perspective, I'd like to explain why Japan and Indonesia are different in the dispute resolution process in car accident. In Japan, that the Japanese case can be characterized by the active role of the insurance company in negotiation. In Japan, that the insurance company has huge information on the estimated amount of the compensation. So that's why that the insurance company knows that if in this case, we can estimate the amount of the compensation very easily based on the jurisdiction or the judgment, previous judgments. That's why that the insurance company can offer to the two parties. Without the judicial process, we can estimate the amount of the judgment. So that rather than consume the too much time and too much expense, maybe should we, how to say, reach the agreed about the compensation without the judicial procedure. So That's why that this how to say, information on the estimated amount of the compensation owned by the insurance company is based on the accumulated consistent judgment by the court. And why court can how to say, produce the consistent judgment? This is a structural factor that the court always based on or refer to the previous judgment. And also that there is why the insurance company can intervene to the many cases because of the high insurance coverage rate. In Japan, that around 70% of the drivers by insurance. That's why that in many cases that the insurance company involved, and the insurance company can, how to say, intervene to the dispute resolution process. This high insurance coverage rate is based on the risk aversion culture in Japan. This is a cultural factor. And also that why people tend to avoid the judicial process because the lack of the how to say, very poor legal counseling. Because in Japan, that the number of the lawyers is very limited. That's why that sometimes the people feel hard to find the credible lawyers. That's why that rather than how to say hire the lawyer and bring the case to the court, that the people tend to follow to the proposal by the insurance company, and they decided to agree the amount of the compensation without the court process. This is the Japanese situation. Indonesian situation is that the first is characterized by the informal negotiation oriented. First, by the law police involvement, because in Indonesia, traditionally, police is more security oriented rather than civil service, because that the police have been a part of the military, that the civil police have more security oriented rather than civil service. And also that in Indonesia, once the case brought to the court, it becomes an endless court game. It's a litigation as a starvation tactics or word of the attrition. Maybe this is can be culture of the court and culture of the lawyers. And also that why that the judicial procedure became the endless court game, because the Indonesian civil procedural law or the penal procedural law recognize the widely accepted reason for the appeal. And sometimes that the reason for appeal is not the widely, but almost unlimitedly accepted. That's why it's very easy to appeal the cases to the higher court. And this makes the endless court game. So that's why that the process of the dispute resolution affected by the culture and the structure, even though that the content is same. Okay. So now I'd like to move to the conclusion. Sorry that I just, when I make this conclusion, I realize I use the Bahasa Indonesia. Sometimes I confuse that. I wonder that which language I use. Now I want to change my language to the Bahasa Indonesia. Maaf, saat saya bikin conclusion part, bagian konklusi, saya baru sadar, oh ya, saya pakai bahasa Indonesia. Makanya, tapi saya pikir malas ganti bahasa. Makanya saya akan menjelaskan conclusion, kesimpulan dengan bahasa Indonesia. Kesimpulan pertama adalah ada kemiripan hukum Indonesia dan Jepang karena kedua negara mewaris hukum Perancis walaupun beda jalur dan sejarah. Tetapi fungsi aturan hukum serupa, sangat berbeda antara kedua negara. Presentasi ini ambil contoh fungsi pasal tentang total liability, pasal 1365 KUHP Perdata Indonesia dan pasal 709 Sipil Kode saat kecelakaan mobil. Di Jepang, perusahaan asuransi berperan aktif dalam negosiasi dan penyelesaian kecelakaan untuk menetapkan ganti rugi dan tidak banyak kasus dibawa ke pengadilan. Sedangkan di Indonesia, banyak kasus kecelakaan diselesaikan melalui negosiasi informal antara kedua pihak. Tetapi juga ada banyak gugatan kepada pengadilan. Friedman menjelaskan bahwa fungsi hukum ditetapkan bukan hanya oleh ketentuan perundang-undangan, konteks, tetapi juga oleh struktur dan culture. Dan kesimpulan kedua, dalam rangka mencapai negosiasi, perusahaan asuransi memanfaat informasi tentang putusan-putusan hakim atas kasus kecelakaan, seperti jumlah ganti rugi dan kriteria pembagian kesalahan, bertanggung jawab atas kesalahan. Perusahaan dan pihak berkait bisa estimasi akibat sengketa karena ada putusan-putusan konsistensi. Ini unsur struktur. Selain itu, banyak pengemudi mobil Jepang memberi asuransi rata-rata 70%, hingga negosiasi bercenderung menjadi negosiasi antara perusahaan asuransi. Keadaan ini dipengaruhi oleh risk aversion culture di Jepang. Budaya pencegahan sengketa, risk aversion culture, budaya pencegahan sengketa menjadi dasar struktur, yakni sedikitnya jumlah pengacara. Sedikitnya pengacara memperkuat budaya pencegahan sengketa di Jepang. Sedangkan di Indonesia, unsur struktur bisa dikatakan bahwa polisi sebagai bagian tentara berorientasi security daripada pelayanan sipil. Makanya masyarakat tidak ingin memperlibatkan polisi saat ada kecelakaan. Takut polisi. Ditakut polisi. Dan pengadilan Indonesia juga punya legal culture mencari keadilan pengadilan dari atas, dari penguasa, daripada penyelesaian sengketa antara kedua pihak yang serata. Kultur ini, budaya ini menjadi penyebab struktur acara perdata yang mengenangkan petisi banding secara sangat luas, hampir unlimited, hampir tidak ada batasnya. Tetapi struktur ini memperkuat budaya untuk menggunakan pengadilan untuk tempat war of attrition atau starvation tactics, endless court game. Ya, makanya saya mengatakan itu ada mirip atau perbedaan, tapi kita harus lihat struktur dan budaya untuk membanding Indonesia dan culture di dalam comparative legal study. Terima kasih banyak. Ini sekian presentasi saya. Thank you very much. This is the end of my presentation.
For giving us such informative and exciting presentations. Then the second speaker is Mr. Khanif PhD to deliver his presentation. Actually, here I want to read some the curriculum vitae about Mr. Khanif. Mr. Khanif is a lecturer in the law faculty. He is the chief of the Center of Human Rights in Multiculturalism and Migration. And then about the background of education, Mr. Khanif PhD is a Master of Law in the University of Lancaster. And then the Doctor or PhD in the University of London in School of Oriental and African Studies. Actually, about the publications, he has many books, international journal, national journal, and proceeding that related with their interest research. So now, please, Mr. Khanif PhD to give us presentations about the influence of Islamic law toward the Indonesian legal system. So Khanif PhD, the room is yours.
Okay, thank you very much, moderator, my best colleague, the Dean, Professor Noor Harisudin, my best colleague too, Yuzuru Shimada. It has been for a while. We didn't meet each other during the pandemics. And of course, I'm very happy we meet again in this occasion. And ladies and gentlemen, participants of the conference, good afternoon, good morning, almost afternoon. I have 8 slides of presentation. I hope I will not cross the border of the lines of the time because I have only 30 minutes of the presentation. The topic that I choose for this presentation is that the influence of Islamic law in Indonesian legal system, and it is quite classics, but I think the topic is still relevant to discuss, especially about the trend of Perda Syariah, and also the trend of the Kanun Jinayah in Aceh and some in and other some districts level. So I begin with the wait a second. So I still remember when we read the history of the formation of the state, that Indonesia is basically different with some states in Europe, or maybe perhaps in Japan, or maybe in North America and some other countries, where in Europe we see that maybe most of the states were actually the reincarnation of the monarchy state. For example, in Britain, you see the monarchy system before they give the prime minister to run the state, and also in Sweden, in Belgium, Islands, and in the Netherlands, maybe in France, where all of these states are basically the reformulation of the monarchy state, and then they build very concise and very condensed state where the law was created based on the monarchy system actually. But it is different with the formation of Indonesia, where in the past, during before the colonial era, we have so many kingdoms. We have Islamic kingdom, we have Hindus, we have Buddhists, we have and they during the colonial era, they fought against the Dutch based on their own interests. For example, in Aceh, we have Cut Nyak, for example, and Tuku Umar, and they fought with the Dutch with their own interests. In West Sumatra, we have Padri War, where the war was between traditionalists and Wahhabism. While in Java, we have the Kingdom of Yogyakarta in Solo, and in some other areas where actually the fight, the war against colonials were based on their own interests. So based on this the long historical process of the formation of the state, it is very common that some mass organizations, especially religious organizations, they have very strong influence against the formation of the state. For example, if it is very Java-centric, but we don't neglect that the role of Muhammadiyah, Nahdlatul Ulama, and Persis, they have very strong influence on the formation of the state, and also the drafting of the constitution, where we all know about the Piagam Jakarta or Jakarta Charter, where some Muslims and some Islamic organizations, they really forced to bring Islamic law in front of the formation of the state in Indonesia. So based on this long history, so we can differentiate, but of course it is very general and very common. If we can break down the level and maybe the group of the Islamic organization, perhaps we have more organization involved, but in general, we can differentiate the influence or maybe the role of the Islamic organization toward the formation of the state into three. The first is reformist or maybe nationalist. I put question mark because the terminology of reformist is quite blurred, because in some other areas, Muhammadiyah is not reformist, but it is about more about the maybe not fundamentalist, but perhaps it is also traditionalist too. But in some other areas, many researchers prefer to name Muhammadiyah as reformist and nationalist, because the main reason of their Islamic jurisprudence or maybe Islamic fiqh is that they don't believe that the ijtihad is already closed. So they are still building their own ijtihad. to seek the truth and the justice in Islamic law. But in fact, of course, in the development of the Indonesian legal system, we all know that the Muhammadiyah is not reformist. In some other areas, they are even traditional, perhaps some are fundamentalist. So after Muhammadiyah, we see an Nahdlatul Ulama, where most researchers call them as a traditionalist, but some others also call them as post-traditionalists. So they don't use modernist, because some modernist thinker in Nahdlatul Ulama, they are still small and often outnumbered by traditional voices in Nahdlatul Ulama. But I think what Muhammadiyah and Nahdlatul Ulama share in a common areas is that both of them prefer to establish Islamic establish Indonesia as a secular state, or maybe religious secular state. In my own terminology, I prefer to say that Indonesia is a theistic secular state. So theism is referring to the acknowledgement and the protection of non-Abrahamic religion, but also we have so many local religions, local belief that they must be protected equally with the Abrahamic religion. So the third one is Islamic unity or persist, where in some discussion and some debate during the colonial era, persist also influence the thought of Muhammadiyah and also Nahdlatul Ulama. For example, Ahmad Hasan was the strong supporter of the Islamism in Indonesia, and also tried to convince Muhammadiyah and Nahdlatul Ulama to establish an Islamic state in Indonesia. Of course, during the period of time, Islamic unity or persist is losing their significant contribution to the formation of the state because of the political history of the Orde Lama and Orde Baru, or World Order, New Order and Old Order. So about the Islamic discourse of the formation of the state, wait a second. So Islamic discourse and Islamic law discourse are different. While Islamic discourse deal with the interrelated concept of politics, theology, law, and human rights. So of course, Islamic discourse is much broader, much wider, or maybe heavier in the formation of the Indonesian legal system. While Islamic law is smaller than Islamic discourse. And during the formation of the state, before the Reformasi era, Islamic law is have very limited jurisdiction. It is only in family law, primarily about marriage and divorce. While after the Reformation era, the role, the significant contribution of Islamic law toward the formation of the law of the state is getting broader and heavier, because the autonomy law, which authorize local governments to introduce and also to adopt and enacted bylaws based on their own interests. So it created, I think, a wider spectrum of the Islamic law toward the formation of the Indonesian legal system. For example, in some other areas, of course, Aceh is very exceptional, because after the Helsinki Agreement in 2005, the central government authorized Aceh to produce and also to implement their own law. And unfortunately, I think the government of Aceh prefer to use Kanun Jinayah. Kanun has many names, but I think one of the most controversial Kanun is Kanun Jinayah, and also the procedural of Kanun Jinayah, or Hukum Acara Kanun Jinayah, where maybe yesterday or maybe 2 days ago, if you follow the one case in Aceh, where there was a man seduced his own daughter and then the case brought before the court, and then the man was freed by the Mahkamah Sharia, because the Mahkamah Sharia believed that the evidence is not enough, because in the procedure of Kanun Jinayah, visum is not evident. Perhaps CCTV, if we have CCTV, is not evident, because in Kanun Jinayah procedure, the evidence must be 4 persons who witnessed perhaps the sexual intercourse, and also children is not allowed, or they are not authorized to give witness in the Mahkamah Sharia. So this is the problem about the implementation of Kanun Jinayah. But in some other areas, like in Bulukumba, or maybe in central, maybe in South Kalimantan and in West Java and Sumatra, they start to implement and to introduce Perda Sharia, or maybe Perda Sharia nuance. I prefer to use nuance, because I think in Indonesian legal system it is not allowed, or maybe it is religion is restricted to put their own interest in the Indonesian legal system. For example, if we read the living regulation, we will not see any name of Islam, for example, or any other religion in Indonesian legal system, because it is not allowed. But the nuance of religious law is very, very strong. Everyone can feel it. Everyone can. Everyone knows that after the Reformation era, the nuance of Perda Sharia is increasing. So when the Islamic discourse and Islamic law discourse are meeting each other, so the problem is that in some other cases we see that there is overlapping between Islamic discourse and Islamic law, where if in some, for example, in the Babun terminology, Islamic discursive tradition continues to provide a worldwide universe of the past and the present interpretation of the Quran and Hadith. And if we see some verdict of the court, for example, we can see that during the hearing before the court, there are some religious leaders and maybe some fatwas that were read before the court, and then the judge also consider fatwas from MUI, Majelis Ulama Indonesia, as one consideration, maybe one of the most one consideration to adopt the verdicts. This is, I think, the overlapping between Islamic discourse and Islamic law discourse. Well, Islamic discourse, we cannot neglect the significant contribution of Islamic discourse during the formation of the state. But I think we should also differentiate between Islamic discourse and Islamic law discourse, because in Indonesia, as a theistic secular state, it is not possible for any single religion to put their name, or maybe to influence their religious values, or maybe religious norms in Indonesian legal system. But in fact, we all see that the trend of the influence of Islamic law during the enactment of bylaw or perda is increasing. So this is the variant interpretation of Islamic law in Indonesia. So I met some one professor during my study in the UK, and then he said that Indonesia is very unique because as the world's largest Muslim population, populous countries, Indonesia doesn't adopt Islamic law, but also in Indonesia you can find very radical sources, reference, maybe academic reference that discuss about radical theology, radical thought, or maybe radical perspective about not only about religion but also about Marxism, about everyone. You can read almost many things, everything in Indonesia. You can read Plato, you can read Che Guevara, you can read Marxism. Even though Marxism is restricted in Indonesia, but of course, you still can read the books about Marxism, but on the other hand, you can also easily read or maybe find the books which provide the radical Islamism, for example, maybe radical Islamic law to be implemented in Indonesia, maybe some other and also some other issues. So if we see about these two different pools, radicalism of religion and radicalism of ideology, maybe Marxism or maybe capitalism or maybe liberalism, we can see that in Indonesia, basically, Islamic jurisprudence is also very multi-voices. As we already know that the NU already adopted fatwa during the Japanese war, or maybe the war against Japan, and also the war against the Dutch, but also to fight against colonials. But in some other issues, Persis also adopted fatwa, which consists of a very radical theology, radical interpretation of Islam, of Islamic law, where one of the most common character of the fatwa from Persis is they want to have a very full implementation of Sharia in Indonesia, and also they want to move and maybe change the syncretism in Indonesia, and then they want to look back into Quran and Sunnah and Hadith, then where of course it is one of the character of some Islamic school of law in Islam. Well, in some other areas we also easily find moderate fatwas, moderate thinking from, of course, in the past we have Munawar Khalil and Hasbi As-Siddiqi, and in the current situation we have for Syed Akil Siraj, before we have Gus Dur, the late of Gus Dur, and many things, we can easily find these two discourses in Indonesian legal system. So, and also in the past 5 years, maybe in the past 10 years, we also see that some Muslim thinker, they introduce Indonesian fiqh or Islam Nusantara, where they call it as a progressive Islam. So this is the gap of the Islamic jurisprudence in Indonesia, and we still don't know who will lead or maybe who will win in this discourse. Yeah. It's really depend. So the spectrum from this, the gap is that recognizing Islamic discourse is of course part of the human rights, because it is of course it is that if we don't recognize a Muslim to implement their law, because Islamic law is the only religious law which is still active today, because after the Enlightenment era in Europe, we don't see any countries in Europe which implement Bible law, or maybe Christian law, or maybe religious law. So of course, recognizing Islamic discourse is part of legal pluralism, and also it is to protect Muslim personal law and Muslim political rights. But of course, it has like the barrier, or maybe the jurisdiction. Yeah. So, an monolithic perspective of Islam rather than admitting various interpretation of Islamic law, Islamic jurisprudence is unavoidable, because in Indonesia, for example, sometimes we find that fatwa from MUI is much stronger than regulation, even though fatwa is not in the hierarchy of Indonesian legal system, but it is unavoidable, because of course, as a Muslim, the most Muslim populous countries, the voice of Muslim cannot be neglected in the Indonesian legal system. The expansion of secularism has challenged Islamic orthodoxy, because of course, after the establishment of the United Nations and also the enactment of International Convention or Covenant of Human Rights, Indonesia has ratified many of them, and Indonesia has been perceived by many international organizations as very progressive countries, because Indonesia dare to ratify many international convention on human rights. And Islam is perceived more than a religion, and of course, it is the fact that for most Muslim people, they prefer to look back into Islamic law rather than to adjust their thinking and then they adjust their religious norm, or maybe fiqh into the and then they adjust fiqh into the realm of international human rights instrument. So one of the most controversial, maybe the difficult issues in this spectrum is that both Islamic law and international human rights instrument and maybe Indonesian legal system, they establish particular ethic and morality within society. And in some cases, Islamic law is much stronger than international human rights instrument. But in some other cases, Indonesian law is also much stronger than Islamic law. So another spectrum is that Islam has been used to legitimize political gains and mobilize public opinion. It's of course when the discussion of minority rights, maybe Sogi or maybe LGBT or maybe Shiites or maybe Ahmadiyah. So Islam has been very strong to influence not only government in adopting some political policies, but also influence some judges when they want to adopt verdicts or maybe decision. For example, in Tajul Muluk case, if we read the story of the hearing, many NU leaders in Sampang and also MUI in Sampang, they were present in the hearing before the court. But of course, if we have these two parties in the hearing before the court, and then they were invited by the court to provide the witness and also saksi ahli, might be expert witness, it is very unlikely that Tajul Muluk will not will be freed, because it is very difficult for Tajul Muluk to avoid the verdict, because the verdict will, of course, will officially consider the explanation from the NU and MUI of Sampang. And also, but in some, if we see the history about the enactment of marriage law, 1974. So there was a mass demonstration in the parliament, and it was led by P3, Partai Persatuan Pembangunan, Unity Party, because P3 believed that Article 1 of paragraph 2 of the marriage law was contravenes with the Islamic law, because in Islam, marriage is valid not because of the marriage is registered by the state, but because it follows the Islamic rules, Islamic law. But in the marriage law of 1974, the marriage will be valid if it is not only done based on religious belief, but also registered by the state. So P3 at the time believed that it is blasphemous, because in the Quran we will not see any explanation or maybe verses which say that marriage is valid if it is registered by the state. So of course, yes, in this case, Islamic law is losing its rules. So managing and controlling Islamic law in Indonesia. So I choose there are, of course, there are many arguments. There are many proportion about the relation between Islamic law and the formation of the state. So I choose maybe this is one of the best example where Indonesia is establishing plurality of religious state, where this religious state is ideal for denomination and equal treatment in a deeply diverse religious society. Of course, it is not possible to establish Islamic law to protect this diverse religious society, because the example of in the Middle East, for example, might be in Aceh, where Kanun is actually exclusively for Muslim, but in fact the implementation of Kanun is also targeting non-Muslim. It is the evidence that we must consider to establish Islamic law in Indonesia. So MUI fatwa is not legally binding, but sometimes it has significant roles. Maybe it is much stronger than regulation, Indonesian regulation in Indonesian legal system. So this is my last slide of presentation. I remember when Daniel Saleh in 1982 wrote about the very phenomenal theory about the legal system in Indonesia and how justice is established by the court. So in his very long inquiries in Indonesian legal system, he believed that justice in Indonesia is not established based on the true and false, or maybe crimes and maybe fairness, but justice is established just to restore social social cohesion, which was broken because there was a crimes. So that's why all parties, when they brought the case before the court, they must ready to lose some of their rights, but on the other hand, some other parties also dare to lose some of their rights just to establish justice. So the best example is the Chikasek case in 2011, where 3 Ahmadiyya were dead because of the attack from the headliner Islamic groups. But then 1 Ahmadiyya was charged doing a crime, and then he was put in prison for 8 months, while some other attackers also put in prison for 8 months. So the judge believed that if Ahmadis follow the rules from the police, not to have a gathering in the Sunday morning. So there was not the incident, but then Ahmadis in this verdict, I read that Ahmadis, of course, they don't want to dissemble the gathering, because it is a common gathering. Everyone has freedom of association, not only Ahmadis, but also from NU, from other Islamic organizations. So this is why then the justice where the judge choose is that both parties were blamed. So both parties, the judge believed that both parties doing the same crimes, and then they all charged by the judge to stay in prison for 8 months. So this is the end of my presentation. I hope I do not transgress the time jurisdiction. Thank you very much.
Thank you very much, Mr. Khanif PhD. Ladies and gentlemen, now come to the questions and answer seasons. Actually, here I have several questions. And before I want to read the chat question, there is a participants raise hand in this virtual Zoom. Actually, Muhammad Ikram. Hello, Muhammad Ikram. Is there any in this room? Okay, maybe there is a bad connection from Muhammad Ikram. Actually, there is a raised hand. But here I want to read the question from the chat. This question to Professor Shimada. The first is from the Muhammad Khariri, Mr. Muhammad Khariri from the Kiai Haji Ahmad Siddiq Jember University. The question is about what is the legal system adopted by Japan, considering that Japan in history has not experienced colonialism. And then the second question from the IAIN Ponorogo, he is Mr. Yudi. The question is about was there any influence American law in Japan and had on civil law after World War II? Okay. And then the other question is from IAIN Ponorogo, he is a lecturer. The question for the Dr. Khanif, PhD. Actually, Indonesia have 5 regions recognized based on the 5 principles of Indonesia, or we can say in Pancasila. If that's about the related with the legal system, how each region can support and connect with the legal system in Indonesia. Okay. The first, Professor Shimada, have you got the questions?
Okay,
Okay.
Thank you. Thank you very much. So there are 2 questions about the impact to the impact of the lack of the colonial experience in Japan to the current legal system, and the second one is the influence of the United States to the Japanese civil law system. Okay, so both are very interesting point. So, but about the question from the Muhammad Khairi is in Bahasa Indonesia. Should I answer in Bahasa or English?
Actually, Mr. Muhammad Khairi give us Indonesia questions, but
Okay.
no, I have translated to English.
Oh, okay. No way that I can answer both in both language, but so okay. So in English. So yeah, of course that there is because Japan is not colonized by any other European countries, but Indonesia have been colonized in the Netherlands. So this is a very big difference. That so for the Indonesian society, there is no choice except to receive the Dutch law. So, and all the education, modern education in Indonesia, including the legal education for the elites, native elites, is done by the Netherlands, and only that they taught in the Dutch. So that's why that there are no choice for the Indonesian society other than Dutch law. But in Japan, it's different. Japan, fortunately, are not colonized by any other country, so that there are no colonial imposition over the Japanese legal system. So Japanese government, after the modernization, maybe that around the modernization period, Japanese government can defer the various legal system by dispatching the missionaries to the surveying observation missions, diplomatic missions, and also that the Japanese government sends the young students to the various European countries, not only France, Germany, the US, Italy, England, and etc., to learn the state system in European countries. And then Japanese government compare the various system, and they decide that which one is the most suitable for the Japanese society or Japanese condition. And they decide that the French legal system, French code, is the most developed codes, legal codes at that time, and Japan decide to accept the French legal system. But after that, along with the the changing of the society in both in Japan and Europe, that the Japanese in Japan, the opinion also changes. So that the majority of Japanese politicians claims that we shouldn't accept the French law anymore because the French law based on the individualism. It's the individualism. Individualism is not fit with fit for the Japanese culture. So we should accept the German legal system because the Germany has a king. It's similar to the Japan, which has the emperor. So and they consider that the German system is more suitable for Japanese society. And finally, Japanese parliament adopts a new civil code, which based on the German civil code. So like that. So, but also that in Indonesia, that all system come from the Netherlands. But in Japan, the state system is a hybrid. That we introduce the civil code from the German system, and we accepted the penal code from the French system. We accept the central bank system from the Belgium, parliamentary system from the England, and also that maybe it's related to the second question. The constitution. First, we accept the constitution from the Germany, but after that, due to the defeat of the World War II, Japan accepts the American system. So like that, because we don't have the colonial experience, that Japan can choose the legal system. But it is one of the it causes the inconsistency of the each legal system. So and this is a very important issue of the legal study in Japan, how to reconcile or how to harmonize the different laws from the different legal system. This is one of the academic topic, having the academic topic in Japan. About the impact, second question, about the impact of the United States Japanese civil codes. Actually, that the Japanese civil codes is, it says, that even after the World War II, that the Japanese civil codes doesn't change significantly. But there is a very big change is in the civil code. It's the status of women. Because before that, status of women are inferior to the male status. So that always daughter or the wife have to follow to the father. And marriage recognized as contract between the families. But after the World War II, that because of the pressure from the United States, Japan enacted a new constitution, which based on the equality of the gender. So because Japanese constitution accepts the gender equality, that's why that Japanese civil code also accepted the principle of gender equality and the definition of the marriage and the process of marriage is changed in accordance with a new constitution, which are imposed by the United States. I hope this is the answer for the second question. Thank you.
Thank you very much, Mr. Professor Shimada. Then about the second question is, was there any influence American law in Japan has on civil law after World War II?
Ya, I already saya kira saya sudah jawab karena apa? Sebetulnya KUH Perdata Jepang tidak begitu berubah secara signifikan walaupun setelah Perang Dunia Kedua. Tetapi Jepang ada satu perubahan yang sangat signifikan adalah kedudukan wanita. Sebelum Perang Dunia Kedua, kedudukan wanita selalu di bawah hak kedudukan laki-laki. Misalnya istri atau anak perempuan harus selalu mengikut mengikut kepada ayah sebagai ketua kepala keluarga. Tetapi setelah Perang Dunia Kedua, Jepang mengamandemen Undang-Undang Dasar oleh tekanan Amerika, dan Undang-Undang Dasar baru ambil salah satu prinsip kebersamaan equality of gender, kesetaraan laki-laki dan perempuan. Dan dengan karena Undang-Undang Dasar sebagai negara tertinggi di undang-undang tertinggi di Jepang mengambil asas gender equality, makanya Civil Code juga mengubah pasal-pasal berkaitan dengan perkawinan, dan hingga pasal-pasal KUH Perdata tentang perkawinan berubah hingga itu kedudukan laki-laki dan wanita dalam keluarga itu sudah dimodifikasi, dan acara pernikahan atau hak waris dan lain-lain sudah juga diubah. Mungkin itu pengaruhan Amerika Serikat kepada KUH Perdata Jepang.
Okay, after World War II.
Terima kasih.
Thank you very much, Professor Shimada. And this question will be answered by Dr. Khanif, PhD. About the Indonesia have 5 religions. Okay, the time is yours, Mr. Dr. Khanif, PhD.
Indonesia has 5 principles of Pancasila. Is that correct?
Indonesia have 5 religions recognized based on the 5 principles in Indonesia, or we can say in Pancasila. But about the legal system in Indonesia, actually, each religion have a different statement between a religion. So, how the 5 religions can support or with the legal system in Indonesia?
Okay. Recognizing religion is, of course, different with because recognizing religion is part of religious discourse. It is not part of the religious law discourse. So when the state recognize religion, means that religion is equal with individuals in terms of the recognition of the state. So if we see the formation of the state, we will not find any single laws in Indonesia which authorize a certain religion to jump from their private realms into the public realm.
Hello, Dr. Khanif, PhD. I think Dr. Khanif have a bad connection. Okay, maybe Dr. Khanif, PhD have trouble in their connections, or maybe have bad signal. Okay, Dr. Khanif, PhD, can you hear my voice?
I'm sorry.
Okay.
Yeah, I'm sorry. Yeah, sorry, because trouble in connection. So recognizing is not same as authorize a certain religion to put their norm in Indonesian legal system, because religious discourse is different with the legal discourse. What we must think is that there is an overlapping between religious discourse and legal discourse in Indonesian legal system. For example, like the the adoption of the verdicts of as I explained in the presentation, Tajul Muluk and also Chikasi case and perhaps some other cases where the judge and the legal institution also consider Islamic law, not only Islamic discourse, because Islamic discourse is, of course, it is should be stay outside of the court and outside of the judicial institution. Of course, Islamic discourse can have influence in the parliaments, or maybe in the executive organs, but not in the legal realms. So yeah, this is my my arguments that recognizing religion doesn't mean that the state authorize a certain religion that has been recognized by the state to put or maybe to write down their religious norm in Indonesian legal system.
Thank you very much, Dr. Khanif, PhD. From the other question, maybe for the participant who want to make raise hands here. Okay, thank you. For the Dr. Miftahul Huda from IAIN Ponorogo, maybe you can turn on your camera and please give us questions.
Okay, thanks very much, Ms. Moderator, Ms. Ima. I think this afternoon there was an interesting discussion delivery by Al-Khani PhD and Mr. Shimada. For Mr. Shimada, in his explanation, Shimada gave a statement that there are similarities between Indonesian law and Japan law. One of the indicator is inheriting French law. I'm sorry, Mr. Shimada. I think Indonesia, in the historical context, may not meet French law. Can you explain what is the most important evidence of the relationship between Indonesian law and French law? I think is a new explanation for me. There are any similarities or any connection in Indonesian law and Japan French law. To Al-Khanif, thank you for your explanation, but one question for you. There are many stakeholders whose influence the relationship of the development of Islamic law in Indonesia, like the state, Islamic organization like Majelis Ulama Indonesia, Nahdlatul Ulama, Muhammadiyah, and so on. I think we are a religion society. We are a religion society, but the state is not a religious state. Yeah, but the state is not religious state. How for the ideal scheme, Mr. Al-Khanif PhD, for the ideal scheme in ensuring the position of Islamic law in the context of the state administration? I'm sorry if my English is not so good. Yeah, I think enough. One question for Mr. Shimada and Al-Khani PhD. Thank you, Ms. Ima.
Thank you very much, Dr. Miftahul Huda. And the time for Professor Shimada, please give answer from the question from the Dr. Miftahul Huda. Thank you.
Terima kasih Bapak Huda atas pertanyaan sangat penting, karena tadi saya mungkin pakai bahasa Indonesia ya, biar itu bisa dimengerti lebih jelas.
Boleh.
Ya. Tadi saya menjelaskan bahwa ada hubungan antara hukum Indonesia dan hukum Prancis, dan mungkin ada kekurangan penjelasannya. Kenyataan sejarah itu seperti ini, dan setelah Revolusi Prancis, tentara Prancis menguasai Belanda, dan Belanda jadi menjadi satu bagian Prancis, dan selama ada di di bawah Prancis, masyarakat Belanda menerima hukum Prancis. Tapi setelah itu Belanda kembali kemerdekaan. Dan setelah kemerdekaan ada kontroversi di dalam Belanda. Apakah Belanda tetap menggunakan kitab-kitab hukum yang ditekan oleh Prancis atau punya kitab sendiri berdasarkan budaya Prancis? Dan ada kontroversi hukum di dalam Belanda setelah kemerdekaan tahun 1815. Ternyata setelah dalam kontroversi akhirnya yang itu pemerintah Belanda dan pakar-pakar hukum Belanda memilih tetap menggunakan kitab dari Prancis. Akhirnya kitab hukum, kitab perdata, KUH perdata atau KUHP dan lain-lain Belanda tetap itu KUHP yang ditekan oleh Prancis selama ada di di bawahnya Prancis. Dan BW bergerak Wetbook itu adalah salah satu kopi dari itu kan KUH Perdata Belanda, dan BW itu ditekan kepada Indonesia. Makanya jika kita mencari aslinya, mencari akarnya BW, kita akhirnya nyampai kepada hukum Prancis. Karena hukum Prancis diterima di masyarakat Belanda setelah dikuasai oleh Prancis, dan setelah kemerdekaan Belanda tetap memilih menggunakan KUH Perdata di Prancis, dan hukum Belanda itu ditekan kepada masyarakat Indonesia. Makanya saya bisa katakan hukum Indonesia berasal dari hukum Prancis. Terima kasih.
Thank you, Professor Shimada. And the next question for the Dr. Al-Khanif, PhD, the similar question from the Dr. Miftahul Huda. The time is yours to Dr. Al-Khanif, PhD.
Thank you very much. Heavy question, short question, but it is a very long answer. My writing in the Jakarta Post in 2015 explained that the ideal concept of the state in Indonesia is a theistic secular state. Lutfi Ash-Shawkani chose the term religious secular state, and in my Nur Khalis Majid also proposed similar concepts. What I mean about the theistic secular state is that Indonesia as a religious cannot adopt a certain religious norm from a certain religion, because it is very dangerous if someday, or maybe in the past, Indonesia adopt a certain religious norm, because as we all know that the main character of religion is creating their own truth, justice, maybe any other similar norm within their own circle. Like in Islam, for example, of course we believe that Islam is the only religion, the only true religion. Christian will also do the same, while the Hindus, the Buddhists, the Confucians, they will also produce their own circle of truth and justice. So if we want to bring Islamic law from the backyard and then put in the front line of Indonesia, of course it will be very dangerous of the Indonesian unity, because everyone will speak about the truth, the national truth based on Islamic law. Look, for example, in Aceh, where Kanun Cinaya is destroying the social cohesion between Islam between Muslim and non-Muslim. So that's why I say that the ideal concept of Indonesia is a theistic secular state. Indonesia believe in one God, but it is of course the God in Pancasila must be inclusive. Everyone can define their own God. Perhaps local wisdom, local belief, they have their own God. Abrahamic religion, they have different gods. So every God, every belief are equally protected in the theistic secular state. So it will not happen if we establish a certain religious state, because the state will create a certain truth, certain justice based on religious values from certain religion. So this is my argument, that I still stick on my argument. In 2015, I wrote in Jakarta Post where Indonesia is a theistic secular state, and when I also invited by Mahkamah Konstitusi, the Constitution Court of Indonesia, to in a judicial review of Adminduk in 2017, I also proposed this argument that Indonesia is a theistic secular state. Everyone has equal rights to believe and to manifest their religious and their religion and belief.
Thank you very much, Dr. Khanif, PSC. Then a question from the Mr. Barsuki. Okay, the time is yours, Mr. Barsuki.
Ya, thank you so much, Miss Ima. Mohon izin Pak Hanif, saya muridnya jenengan. Prof. Shimada. The first question I will use bahasa Indonesia, Prof. Shimada. I'm so sorry I use Indonesia, bahasa in bahasa. When we are talking disharmony tentang Jepang, Pak Shimada, bahwasanya kalau di Indonesia itu ada sistemnya itu yakni adalah over regulation. Over regulation itu kemudian digunakanlah omnibus law, teknik omnibus law untuk penyelesaian peraturan perundang-undangan di situ. Apakah di Jepang juga melakukan adanya over regulasi juga, Prof. Shimada? Itu yang pertama. Yang kedua adalah tentang penyelesaian sengketa peraturan perundang-undangan. Kita ada namanya alternative dispute resolution. Apakah di Jepang, manakala ada overregulasi, mereka juga ada namanya sengketa penyelesaian peraturan perundang-undangan itu menggunakan alternative dispute resolution based on Permenkumham number 2 year 2019. Itu the second question for Prof. Shimada. And then Pak Hanif, ini pertanyaan saya, Pak Hanif, menarik diskusi kita tentang Fatwa MUI, Pak Hanif, yang mana memang adanya Ahmadiyah dan kelompok minoritas itu seringkali menjadi termarginal di negara Indonesia. Konsepnya juga kalau kita berdasarkan Fatwa MUI, kita juga berdampak itu ke dalam suatu aliran kebencian terhadap kelompok di sini. Yang ingin saya tanyakan Pak Hanif tentang bagaimana membentuk harmoni dalam suatu pluralisme, dan juga bagaimana bentuk untuk protektif melindungi minoritas ini, karena kita hidup dalam, apalagi Indonesia bermacam-macam pluralisme. Asia Tenggara juga pluralis juga. Konsep untuk harmoni dalam pluralisme itu bagaimana, Pak? Terima kasih. Thank you, Miss Ima.
Thank you very much, Mr. Barsuki Kurniawan. For the first questions can be answered by Professor Shimada. The time is your Professor.
Terima kasih atas Bapak Barsuki pertanyaannya. Tentang pertanyaan pertama, jawabannya agak sulit karena definisi overregulation itu susah. Karena mungkin itu ada orang pikir itu undang-undang omnibus cipta kerja adalah overregulation. Tapi itu salah satunya tujuan undang-undang omnibus cipta kerja adalah itu tujuannya deregulasi, menghapuskan banyak regulation, ya kan? Makanya Dan tapi kadang-kadang masih orang pikir, ada yang pikir masih itu intervensi negara kepada aktivitas ekonomi itu masih terlalu. Mungkin itu tentang over regulation adalah konsep relatif dan tergantung pemandangan setiap orang. Dan tapi rata-rata di Jepang dan Indonesia mungkin sejalan dengan globalisasi atau harmonisasi aturan ekonomi, semua negara menuju ke deregulasi. Dari over regulation to deregulasi. Tapi ada arus balik juga, khususnya untuk itu seperti regulasi tentang money laundering, pencucian uang, atau tentang lingkungan global, banyak orang menginginkan regulasi lebih kuat dari negara. Ya, kemarin itu World Bank dan G20 sudah sepakat untuk menetapkan taraf minimum untuk pajak perusahaan hingga 15%. Karena mungkin di perusahaan minta deregulasi tentang pajak perusahaan, tapi semua negara yang ikut G20 sepakat menetapkan minimum pajak minimal di perusahaan itu 15% supaya perusahaan tidak mencegah kewajiban pajak. Seperti ini. Mungkin itu ada regulation atau over regulation itu memang relatif, dan juga walaupun secara umum itu harusnya kepada deregulasi, tapi ada tetap itu ada arus balik yang bilang perlunya regulation lebih banyak. Mungkin itu kita masih bisa lihat keadaannya. Mungkin karena susah jawab kepada pertanyaan itu karena susahnya mendefinisi over regulation. Makanya mungkin jawaban saya tidak pas untuk pertanyaan. Dan kedua tentang keberadaan ADR, Alternative Dispute Resolution. Ya, di Jepang juga ada banyak sistem, tapi tidak ada kayak di Indonesia Badan Administrasi Negara Nasional Indonesia. Di Jepang itu di setiap bidang ada lembaga ADR atau lembaga ADR yang didirikan oleh swasta atau bukan negara ada. Misalnya hari ini saya bahas tentang kasus kecelakaan mobil. Itu ada juga satu traffic accident arbitration center, pusat arbitrasi kecelakaan mobil. Itu untuk mengadakan menyelesaikan sengketa secara ADR tentang kasus kecelakaan mobil. Karena saya sudah katakan, itu di Jepang sudah ada akumulasi putusan-putusan hakim tentang kriteria ganti rugi atau pembagian kesalahan. Makanya daripada membawa kasus kepada pengadilan, di pengadilan butuh waktu dan butuh biaya, mungkin pihak-pihak bisa membawa kasusnya kepada pusat arbitrasi kecelakaan mobil, supaya bisa mendapat penyelesaian lebih cepat dan lebih mudah. Ya, ada seperti ini. Apakah ini, semoga itu jawaban saya kepada pertanyaan. Terima kasih.
Thank you very much. Thank you, Professor Shimada. The next question for Dr. Khanif, PhD. The time is yours for the answer the question from the Mr. Basuki.
Okay, thank you very much, Pak Basuki. The substance of harmony is that respecting and protecting must come from both sides. For example, do we lose our faith if, for example, we recognize and protect minorities? Apakah kita kehilangan keyakinan kalau kemudian harus menghormati Ahmadiyah? Of course not. Do we lose our faith if, for example, we fulfill the right of, for example, sexual minorities? Of course not. Apakah kita akan kehilangan keyakinan, ketauhidan kita kepada Tuhan kalau kemudian kita menghormati kelompok-kelompok minoritas seksual? Of course not. This is harmony. Apakah do we lose our faith, for example, if we do not implement Sharia law in Indonesia legal system? Apakah kita kehilangan keyakinan kalau kita kemudian tidak menerapkan syariah di Indonesia? Of course tidak. Karena syariah is personal. So this is the questions to answer about the harmony. While in Indonesia, harmoni itu diterjemahkan sebagai minoritas harus manut kepada mayoritas. That is of course totally wrong in terms of pluralism. Pluralism means that any single individuals, every groups of individuals must equally be protected. This is harmony. While if we force somebody to follow our faith, it is not harmony. So that is my answer, but not really answering the question, but it is like a philosophical answer. Thank you very much.
Thank you very much, Dr. Khanif PhD. Ladies and gentlemen, we have finally come to the end of this conference. Before I close the conference, I would like to conclude what the speakers have presented. For the first, from the Professor Shimada, there is the similarity between law and between law Indonesia and Japan, because there is the similarity law from the branches, although we have different way and the histories. And then about in Indonesia, if there is the case, many case in Indonesia, but we can too finish it by informal negotiation between each people. And then the conclude from the Dr. Khanif PhD, Islam has been used to legitimate political gains and mobilize public opinions. And then besides this, Islam influenced the institution to issues on particular case. Ladies and gentlemen, I would like to thank the speakers for the informative and interesting presentations and all the participants, very active participation. Finally, give the applause for the speaker and for all of you. Thank you. Yeah. Ladies and gentlemen, please don't go from the spiritual Zoom, because the closing ceremony will be held on the 10 minutes again.
Okay. Moderator, is it ready? Finished?
Yes.
Okay.
It's finished, but it will be of the international conference.
Say it again.
Hello.
Thank you, Prof. Shimada.
Yeah.
Thank you, Professor Shimada. Thank you, Dr. Khanif.
Yeah,
Thank you
you're
very much,
welcome.
everyone. Thank you.
Thank you very much for
Thank
your
you,
Haris.
Mr. Arhanif.
Hanif. It's,
Thank you very much. Shimada.
see you again sometime.
Really soon, yeah?
Yeah.
Okay.
Okay.
Can we leave now or how?
We have the closing ceremony for the international conference.
Okay, okay.
Kalau itu perlu saya tetap di sini atau apa? Boleh tinggalkan?
You have to stay.
Ya, oke. Saya
Closing.
Tapi saya jam 3 ada rapat lagi. Apa nih?
Okay, okay.
Ya, Hari ini penuh dapat.
Only 5 minutes more. 5 menit lagi.
Oke, saya tunggu.
Excellencies, distinguished guests, participants, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Greeting to all of us. Welcome again to the first International Conference of Law and Islamic Law in Politics, Democratic, and Contemporary Dynamics of Sharia and Law in Southeast Asia 2021. It's very nice to see you all of you once again, and we hope you have been enjoying yourself at the conference so far. We are very honorable to have with us here this afternoon for our keynote speaker, the Excellency Professor Shimada, Excellency Khanif PhD, the Honorable the Dean Sharia Faculty of Kiai Haji Ahmad Siddiq Jember University, Professor Dr. M. Noor Harisudin M. Fil.I, the Honorable the Dean of Sharia Faculty, State Islamic Institute of Ponorogo, Dr. Haji Khusniati Rofiah MSE, the Honorable the Vice Deans of Sharia Faculty of Kiai Haji Ahmad Siddiq Jember University and State Islamic Institute of Ponorogo, and also all presenters and participants, the first International Conference of Law and Law Islamic Law 2021. Excellencies, distinguished guests, participants, ladies and gentlemen, we have had productive and inspiring time together, and these events are about to come to the very end. I will have you have found the presentations on this conference are informative and helpful. No, we will close the conference. We are now going to listen the Dean of Sharia Faculty of State Islamic Institute of Ponorogo, Dr. Haji Khusniati Rofiah MSE, to present us with the closing speech and ceremony. Ladies and gentlemen, please welcome Dr. Haji Khusniati Rofiah MSE.
Okay, thank you very much, Ms. Ima. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Innal hamdalillah nahmadu wa nasta'inu wa nastaghfiruh wa na'udzu billahi min shururi anfusina wa min sayyiati a'malina. May yahdihillahu fala mudhillalah wa may yudlil fala hadiyalah. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh. Allahumma shalli ala sayyidina Muhammad wa ala alihi wa sahbihi ajma'in, amma ba'da. Siyadata Jamil Mutakallimin fi hadhihi nadwatil alamiyah, Profesor Shimada wa Al-Hanif PhD, Siyadata Ra'isil Jami'ah, Siyadata Amiti Kuliyatis Syariah fil Jami'ah Al-Islamiyatil Hukumiyah Kiai Ahmad Siddiq Jember, Profesor Dr. Harisudin Al-Magister, wa jami'i ru'asa di Kuliyatis Syariah fil Jami'atil Islamiyatil Hukumiyah Jember wal Jami'atil Islamiyah Hukumiyah Ponorogo, wa kafati muqaddimil maqalat wal musyarikin al mahbubin fi hadhihi nadwatil alamiyah. Awalan hayabina nashkuru syukran jazilan kasiran ila Allah Ta'ala qad a'tana rahmatan wa barakatan wa hidayatan hatta nastati'a an najtami'a fi hadhil majmu'atil mubarakah fi sihhatin wa afiyah. Wasaniyan hayabina an musalliya ala habibina wa nabiyina sayyidina Muhammadin sallallahu alaihi wasallam alladzi qad akhrajan nas minadh dhulumati ila nur wa ila siratil mustaqim wa a'malat hayatana fi nuril Islam wal iman wal ihsan. Ayuhal hadirun rahimakumullah, Bapak Ibu semuanya, mohon maaf saya ganti bahasa biar enak karena ini penutupan, jadi biar enak ya apa yang perlu kita sampaikan. Alhamdulillah kegiatan kita yaitu seminar internasional kerjasama antara Fakultas Syariah IAIN Jember dengan Fakultas Syariah, mohon maaf, IAIN Syariah, Fakultas Syariah UIN khas Jember dan Fakultas Syariah IAIN Ponorogo dalam 2 hari ini, yaitu tanggal 13 sampai 14 Oktober ini, alhamdulillah bisa berjalan lancar dan sukses. Oleh karena itu, karena kegiatan ini berjalan dengan lancar dan sukses, kami mewakili segenap panitia dan juga keluarga besar dari Fakultas Syariah UIN Jember dan IAIN Ponorogo menyampaikan banyak terima kasih yang besar-besarnya kepada berbagai pihak. Yang pertama kami sampaikan kepada para narasumber sejak kemarin sampai hari ini. Luar biasa, baik narasumber dari luar negeri, Prof. Nadirsyah, kemudian Dr. James Gomez, juga Profesor Shimada, dan juga Khanif SD, juga maupun luar biasa yang telah banyak memberikan ilmu kepada kita semuanya. Mudah-mudahan ilmu ini bisa benar-benar bermanfaat bagi kita semua. Yang kedua, kami sampaikan juga kepada para presenter yang telah mengirimkan paper dan pagi tadi sudah mempresentasikan. Terima kasih banyak. Ini baik yang berasal dari IAIN Jember maupun dari IAIN Ponorogo. UIN Jember, mohon maaf ya, kok kelaru terus ini. Sudah UIN nanti dimarahi Pak Dekan. UIN Jember dan IAIN Ponorogo. Alhamdulillah luar biasa, begitu semangat. Baik dari teman-teman Ponorogo maupun Jember, saya lihat teman-teman Ponorogo ini luar biasa juga, dan juga Jember. Jadi dengan adanya kegiatan ini memaksa teman-teman kemudian harus menulis dan tentunya akan mendapatkan banyak pengetahuan. Kemudian juga kami sampaikan kepada peserta, baik para mahasiswa maupun para dosen ataupun yang dari luar 2 lembaga. Terima kasih yang sudah setia mengikuti acara ini mulai hari kemarin sampai saat ini. Dan perlu kami sampaikan, kegiatan ini tentu sangat banyak memberikan manfaat bagi kita semua. Kita mendapatkan banyak pengetahuan, baik tentang hukum nasional maupun internasional. Kita bisa membandingkan antara hukum yang ada di Indonesia dengan hukum yang ada di Jepang, dengan di Australia, dengan bahkan luar biasa tadi dari Bapak Khanif SD ya, dari UNED Jember ya. Beliau menyampaikan banyak hal tentang hukum Islam walaupun dari UNED, tetapi juga sangat memahami tentang hukum Islam. Kemudian juga dari Prof. Shimada dari Jepang, yang kita tahu bahwa ya hukum-hukum yang ada di negara kita juga masih banyak peninggalan dari hukum-hukum Belanda maupun Jepang ketika dulu di Indonesia. Terima kasih atas pengetahuannya, Prof. Kemudian dari kegiatan ini kita juga selain meningkatkan pengetahuan kita tentang hukum, juga meningkatkan kemampuan dari bahasa asing. Karena teman-teman ini dipaksa untuk mempelajari kembali bahasa asing karena namanya seminar internasional ya. Jadi sedikit banyak harus juga menggunakan bahasa asing, termasuk tadi para peserta. Walaupun mungkin setiap harinya tidak banyak menggunakan bahasa asing, tapi karena ini adalah seminar internasional, maka kita bisa menggunakan bahasa asing di sini sehingga bahasa kita sedikit terasah. saya sendiri juga begitu. Jadi mencoba untuk memahami apa yang disampaikan oleh para narasumber kita, walaupun mungkin juga banyak tidak pahamnya gitu. Oke. Kemudian selain itu tentunya kegiatan ini juga sangat bermanfaat bagi peningkatan kualitas dosen ya, di mana dosen ini juga akan mendapatkan nilai tambahan, nilai kum juga untuk kenaikan pangkat. Selain itu ini juga akan mempererat kerjasama kita, terutama antara dua lembaga. Cuma kami berharap kerjasama ini tidak hanya antara Jember dengan Fakultas Syariah IAIN Ponorogo, sama dengan universitas dari Jepang ya, dari Prof tempat mengajarnya Prof Shimada, mungkin juga dari UNED Jember, dari Bapak Al-Hanif PSD. Saya kira IAIN Ponorogo belum melakukan kerjasama, sehingga saya berharap nanti suatu saat kita bisa melakukan kerjasama. Kalau Jember saya yakin sudah, karena memang satu kota ya, satu kota. Tapi kalau Ponorogo belum. Tapi untuk Jember ini sebenarnya bukan sesuatu yang asing bagi saya sendiri, Pak Khanif. Kebetulan saya dulu pernah mondok di Banyuwangi, kemudian kalau pulang itu sering ke Jember. Sehingga beberapa daerah di Jember sudah familiar gitu. Oke. Mudah-mudahan nanti di lain kesempatan IAIN Ponorogo bisa berkunjung ke UNED Jember. Insya Allah ini kita juga akan ke Unisma, jadi nanti akan beberapa perguruan tinggi umum memang juga perlu kita antara hukum umum dengan hukum Islam. Bapak Ibu yang kami hormati, yang tak kalah pentingnya pada kesempatan ini kami memberikan apresiasi yang sebesar-besarnya kepada panitia semuanya, baik dari IAIN Ponorogo maupun dari UIN Jember. Luar biasa, Bu Ketua, Bu Lumatus Sadah, Bu Dr. Lumatus Sadah, dan teman-teman yang telah mempersiapkan acara ini jauh-jauh hari. Kalau nggak salah 6 bulan yang lalu ya kita sudah mulai mempersiapkan ini. Alhamdulillah pada saat ini sudah terlaksana dengan baik. Mudah-mudahan apa yang sudah dicurahkan oleh para panitia, baik waktu, pikiran maupun tenaganya, ini dapat mendapat balasan pahala yang setimpal dari Allah Subhanahu wa taala dan bermanfaat bagi kita semuanya. Hadirun, kafaitu kalami fi hadhil fursah in wajadtu minni al khotoyat atlubul minkum al afwa wa syukran ila tihmamikum ila liqa fi waqtin ukhra wallahul muwafiq ila aqwamit thoriq. Assalamualaikum warahmatullahi wabarakatuh.
Rofiah, MSA. The last agenda is closing in prayer. The prayer will be recited by Dr. Abdul Wahab, MHE. Time is yours.
Thank you, Ms. Ina. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala asyrofil anbiya'i wal mursalin sayyidina Muhammadin wa ala alihi wa ashabihi ajma'in. Allahumma shalli ala sayyidina Muhammad wa ala ali sayyidina Muhammad. Allahumma ighfir lana dhunubana wa israfana fi amrina wa thabbit aqdamana wa ansurna 'alal qawmil kafirin. Allahumma afrigh 'alaina sabra wa tawaffana muslimin. Allahumma ij'al jam'ana hadha jam'an marhuma wa tafarruqana min ba'dihi tafarruqan ma'suma wa la taj'al fina wa la minna syakiyan wa la matrudan wa la mahruma wa zid lana 'ilman nafi'a bi rahmatika ya arhamar rahimin. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar wa qina al-jannata ma'al abrari azizun ya ghaffar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Bi hurmatil Fatihah.
Thank you very much, Dr. Abdul Wahab, MHI. May the prayer can be answered by Allah Subhanahu wa Ta'ala. Amin, 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 ya Rabbal Alamin. Now, I would leave you with a quote by Stewart Brand, an author and innovative thinker, who once said, "We can see the past but not influence it. We can influence the future but not see it. Let us all be guided by all the things we have learned and heard throughout the conference and be able to see and influence our future." Thank you, and thank you very much. And before we part, please accept this verse from us. Kalau ada jarum yang patah, jangan disimpan di dalam peti. Kalau ada silap yang salah, harap sudi maafkan kami. With lonely men, please forgive us for our shortcomings. Till we meet again, perhaps in the next conference, may all of you have a safe journey home. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam warahmatullahi wabarakatuh. Terima kasih Miss Ima, thank you so much.
Ya, Pak Haji.